Well, good morning and welcome to today's virtual discussion on the HERO Act. I'm Jennifer Sims with the Capital Region Chamber, and thank you for joining us. I'd like to thank Douglas Gerhardt and the team at Harris Beach for joining us today and providing us with these valuable updates. Before we get started, I want to share some Zoom housekeeping for viewing this morning's program. It would be helpful if you select speaker view from the top right of your screen. All participants are on mute, and we ask that you keep your mics muted to eliminate any background noise. We're going to start with a presentation, then go directly into a Q&A session. So if you have any questions, please put it in the chat, which is at the bottom of your screen at any point during the presentation. Today's presentation will be sent to you along with a recording of the presentation. Now it's my pleasure to introduce our presenter. Douglas maintains a diverse statewide practice counseling public and private sector employers on a range of matters that impact the workplace and the workforce. He serves as general counsel, special counsel, and public sector labor counsel to a wide range of clients, including some of the most complex public sector labor clients in the state. Welcome, Douglas.
Thank you. Thank you very much, and I appreciate the opportunity. I welcome everyone here, and I'm glad this forum was able to be made for everyone to learn a little bit about the HERO Act. What we'll do is go through the Act and parse it a little bit, explain the roles and obligations of employers, and there's two main aspects of the Act. It is not overly complicated, but I believe that in its seeming simplicity, it will be complicated in the implementation. So once I go through that, as there are questions, again, as was mentioned, feel free to ask, and hopefully we can answer those and understand that with this law being relatively new, it's possible some of your questions will be, for lack of a better way of saying it, best guess from the legal standpoint until we have a little bit more guidance from some of the regulating agencies. At the outset, I would say to everyone listening, this Act is very important for health and safety of your employees and does have some fairly stringent enforcement mechanisms to it. So unlike, for example, I'm convinced that there are almost no aspect of the law that can't be analogized in some way to driving. So I suppose you could say that you speed at your own risk, and maybe you won't get caught, you keep your eyes open, and maybe you won't get a ticket. That's not how I would portray this law, nor would I recommend, let's hope I don't get an enforcement action. Who would know if I don't do something under this? This is very serious, and it's perhaps one of the more serious laws because it does directly impact health and safety, not only of yourselves, your employees, and those who visit your businesses as customers or clients. So please keep that in mind as we work through this. This is one of those new laws that would be extremely, extremely important to make sure you're fully compliant with. So my colleague is going to be flipping slides for me, so if we can go to the first slide, please. So the HERO Act is, and just to poke a little fun at the state legislature, an acronym that does not easily roll off the tongue or come to mind. It is the Chapter 105 of the laws of 2021. It is the New York Health and Essential Rights Act. A few slides later, I might ask for a rhetorical quiz. Who can remember what HERO stands for? It's problematic, obviously, because the O really doesn't have any help here other than to make a full word. Enough at the poking fun. It is a law that really germinates from the pandemic and seeks to address infectious disease prevention requirements, and I'll emphasize this for all private employers. So someone out there in the audience right now may be raising their hand saying, well, I run a retail operation, I've got 2 full-time employees, 5 part-time. I'm exempt, right? No, you're not, and I'll talk about that in a few minutes. There is also a part of the act that enacts enforceability of safety and health standards aimed at mitigating COVID and other infectious diseases in the workplace. So we can go to the next slide, please. Can I do that? Okay. So private employers, and there are 2 parts: the infectious prevention standards and a joint labor management safety committee. Although it is born of the COVID-19 pandemic, it is not COVID specific. That is, these plans must be responsive for all types of infectious diseases. Let's hope we don't have another pandemic. Let's hope we don't have another COVID or something other than COVID. But were we to, these plans that you're going to be required to put together must be applicable universally. So don't put this out as your COVID-19 mitigation plan. It was just signed in May. It was amended in June. There were some questions that arose about so those chapter amendments were made, and model plans and minimum standards were released just earlier this month. I'll talk about those in a few minutes. Go ahead. Thank you. So under the HERO Act, the infection prevention standards, every private employer must have infection prevention standards adopted. And those standards have to detail employee health screenings, when you're going to do it, how you're going to do it, PPE use, hand hygiene standards, social distancing. You can all read those for yourselves. And as you read those, you realize these are all the things that we implemented over the past year, 18 months, when COVID first came around. These are all the things that we learned were helpful both to prevent the spread and to prevent and to mitigate the impact. So now the infection prevention standards have to be included in here, and it covers all work sites. It doesn't cover employees working remotely. Some of you may have your hand raised, at least figuratively. I have everybody working from home, so these plans wouldn't apply to the home use because you're not in a common area. We can go to the next slide. You need to adopt a model plan, and the legislation sets forth minimum standards for those plans. And significantly, you need to adopt those plans within the next 2 weeks, by August 5th. Now, the Department of Labor has put out model plans, and if you go to the website, you'll see here, I pulled this one up. You can kind of see that. So that's the model plan for personal services. I pull that up because our firm will likely adopt something like that, because that's likely the best category we fit into. But if you go to the DOL website and you plug in HERO Act, you'll see the model plans. They've put them all out there. And initially, what I would do is I would recommend you can do one of 2 things under the law. You can follow the model plan, in other words, adopt it for your workplace, or you can adopt a separate plan that meets or exceeds the standards of the model plan. My personal recommendation is if the Department of Labor is putting out a model plan, I would recommend you follow that and use that rather than try and reinvent the wheel. If there are aspects of your workplace that are particularly unique, and you have perhaps a plan in place that addresses this, given the nature of your workplace, maybe you use that and adopt in accordance with what the model plans set forth. But I think when the regulating agency gives you a model, it's always prudent to follow that. In that regard, when you go to the Department of Labor website, you will see model plans for various types of entities. And for example, like I said, this is the one for personal services. You can see that down on the bottom there, sort of on the right. And here's one for retail. Now, if you initially look at the 2 of them side by side, and I appreciate not everybody can see this real well, they look really, really similar. But as you flip through them, there are differences. So don't assume when you first look at them, oh, they're all the same, whatever, I'll just pick one. The ones for retail envision people who come into your store whereas the ones for personal services, such as a law firm, an architecture firm, whatever, don't, or with less frequency. So they have specific elements to them, and they are different. So I think the Department of Labor has done a nice job to differentiate between the different types of businesses. And as you look at those, make sure you're picking the one that you feel you best fit into. And within 60 days of the model plan being published, in other words, you adopting it, you make that plan available to all employees. You have a lot of notices, perhaps in a break room or in other parts of your employment place, whether it's regarding minimum wage or worker safety. I would suggest you put those there, depending on the size of your workforce. If the plan is of such a type that you can physically hand it to your employees and you only have a half a dozen, you can do that. Email, some mechanism to ensure that the plan is available to everyone so everyone understands what those standards are. Go ahead, we can go to the next slide, please. Again, as I said, I kind of jumped ahead a little bit, but there are different model plans. Look at the right one. Now, this third bullet point is an important point to note. They need to be activated when there's an outbreak as designated by the DOH, the New York State Department of Health. So you need these plans. So right now there's no outbreak that's currently out there. So does that mean your plan, well, I suppose we're at the tail end of COVID, but at the same time with the Delta variant becoming a little bit more prevalent, I would be, I would suggest that maybe you want to implement parts of this. But hand washing, PPE use, whether these are required or not are going to be dictated by the Department of Health. So on the one hand, labor is saying adopt the plan, health is saying when you should be implementing the plan. And that's really helpful. So again, not to burden you with more work, but you'll need to review and update your plans after the Commissioner of Health makes an official designation. And periodically, maybe something else comes out, maybe something else comes about where we need to address work. We've had increased pollution in the air due to the fires out in the western part of the country. And while there hasn't been a designation of a problem right now, folks that have asthma, folks that have difficulty breathing or allergies have had a more difficult time breathing. Maybe your plan needs to address some, outside work environments. So I gave you the link here. It's really easy to find. If you don't want to write this down, just go to the New York State Department. If you Google New York State Department of Labor HERO Act, you'll find those model plans, and you'll be able to look through them and pick the type of business that you are and see what they entail, and you're going to have to adopt that for yourself. Can we go to the next slide, please? The other aspect of the plan, so that's sort of one, and then two is the joint safety committees. Effective November 1st of this year, every private employer with more than 10 employees must permit establishment of workplace safety committees. 2/3 of the committees have to consist of managers and non-supervisors. 2/3 of that committee need to be non-supervisors. A supervisor is an employee with authority to direct and control other employees. This isn't the supervisor isn't the gregarious high school or college kid you've hired for the summer who doesn't let anyone else speak. They need to actually have a supervisory role. The committee has the power to review the employer's policies relating to health and safety, and the committee members can attend initial trainings for up to 4 hours, schedule quarterly meetings no more than 2 hours. So you need these joint safety committees. So earlier I mentioned the notion that the health safety plan has to be adopted by all private employers. This joint safety committee, this is a little bit more, I don't know if I want to say limited or broad, I guess more limited in that it's private employers with at least 10 employees. So the really small employers don't need to ensure the adoption of the establishment of these joint safety committees. Go to the next slide, please. And if the safety committees, let me say that the safety committees won't be required if employers already have a workplace safety committee that's otherwise consistent with the HERO Act. And again, depending on the type of business you are from manufacturing, you're required to have safety committees to ensure a safe work environment. OSHA-like standards are being complied with, then you wouldn't need the safety committee in addition to that. That would take the place of it, provided you check with the HERO Act and make sure your current existing committee is fulfilling the roles and responsibilities that are put forward in this act. Now, the law is silent as to how the workplace committee would be deemed consistent. Don't know whether that was intentional or unintentional. So on the one hand, it says if you have a workplace safety committee in place, you don't need another one so long as it's consistent. What does that mean? I think we will get additional guidance. We still have at least a couple of months before this is impactful and before you have to have it. If we don't, what I would suggest, if you were to call me as your attorney, I would ask to see what you have in place for a current safety committee and compare that to what the new law requires and see if there's any gaps. And for example, the number of times the committee meets, the authority of the committee, and so on, and infuse that into your existing committee, and then I would say you'd be substantially compliant with it, or a reasonable person would believe that you were substantially compliant. A question came up. I'm sorry, I'm not looking at my phone. A question came up: are they per location or per employer? And just looking at the law, it is per business. So those safety committees would be for the business. I think if you have multiple locations, and I can envision a lot of you on this today do, then you would want to ensure that there is a fair representation of folks at your different locations on that committee, representative of the different locations that you have. I realize that it's easy to think about a single location, a storefront or something, but I'm sure many of you have at multiple places of work, so that's what I would that's what I would recommend. Another question is, do you have the question just went away. Do you have a question? How's there?
Do you have to have a committee, or is just the adoption of the plan sufficient?
No, so both. So you have to adopt a plan. That's part one of the HERO Act. Part two is having that safety committee. If you're an employer of over 10, you also have that safety committee. So there are two aspects of this law. So that make sure you have that takeaway of the two elements of it. And the second element, that safety committee is for the 10 or more employer.
And then Douglas, another question that came to me directly is, does this apply to nonprofits too?
Yes, it does not apply to public employers, but it applies to not-for-profits. I'm actually, on my other screen here, I actually have Chapter 105 pulled up here.
And then another question that popped up is,
an employer is literally any person, entity, business, corporation, partnership, LLC, association, employer, employing, hiring, or paying the labor of an individual. There's no exclusion for a not-for-profit.
Okay. And then what if the employees don't want to form a committee? We are 12 employees, but 4 are supervisory.
So the law applies to you. You've got your 12 employees. The law applies to you. And I would say that you would need to, interestingly, if and maybe I'm being a little too specific or a little too lawyer-like on this, but again, I'm staring at the law. Employers shall permit employees to establish and administer a joint labor management safety committee. It then goes into mandates. So the law says shall. So I think if I initially am interpreting this as saying the employer shall permit, you must permit employees to establish this committee. To the questioner, to answer the question asked, if your employees actively say they don't, I would say you probably don't have to, but I would be very, very clear and document if your employees don't want this, because this is a clear key element of this. And to draw back to the policy standpoint a minute, I think the intent behind this is to ensure that employees feel safe in their work environment. And a way to do that is to have these employee-based committees to ensure safety, to ensure they feel protected and healthy in their work environment, and not to curtail that. So if you go to your employees and say, under the HERO Act, you have the right to establish a safety committee. This is what your rights would be under that committee. If your employees universally say we don't want to, I think you would be okay. But I would be very, very clear with informing them of the obligation, and then simultaneously ensuring that there is affirmative commitment or lack of commitment not to do so. So that's how I'm reading the law right now.
Okay.
So
that answers another question that was asked. The law states permits a committee. That permits means mandatory. You must have a committee. What if none of the employees asked to have one? I think that kind of answers that. I think we should probably move on to the rest of the presentation and then go back to the Q&A.
Yep, I was gonna mute you, so I was gonna ignore you that voice size. I actually literally don't have the ability to do that. So in terms of employee protections, I'll put these out there. I'll kind of dance through them a little bit because hopefully they're obvious, but it's important. Employers can't retaliate against employees for exercising their rights under the HERO Act, which includes exercising rights under the prevention plan. Reporting what an employee reasonably believes in good faith is a violation of the HERO Act. Yeah, we have a safety plan, but you know what? They call the Department of Labor, no one's ever wearing a mask. We have no place to wash our hands. You can't retaliate against someone for that. Reporting an airborne infectious disease concern to the employer, or federal or state, local government. And these are, in my mind, really obvious. Like, why would an employer ever retaliate against someone for these kinds of actions? However, I'm employed and have been reasonably successful in the practice of labor law because these things do occur. And it's unfortunate, but I would advise you don't retaliate. These are, and particularly the HERO Act, really very seriously, this is health and safety. And we've all seen it. I suspect there's not a single person on the call on this webinar today that can't identify someone they know who had COVID or has been impacted by it within 1 degree of separation. So these retaliation provisions, I would say, are particularly serious in this case. We can go to the next slide, please. So moving forward, by August 5th, and I know that seems like a world away because July was a washout. We feel like we didn't have part of our summer because July was so wet. By show of hands, how many people have cut their lawn more than ever before? Yeah, me too. Adopt a model plan for your business and design your own plan, meeting or exceeding the state standards. Again, one person's advice, I would use the model plan. By November 1st, assess whether your workplace already has a safety committee that complies with the HERO Act. If not, be prepared to respond to employees who seek to establish that committee. I will say that I applaud the Department of Labor. They have put up a great deal of information about implementation of the HERO Act and its provisions. Again, I gave you the website there, but for those of you who are driving and listening, probably not a good idea. But if you don't want to write it down, if you just literally Google the Department of Labor HERO Act, it'll pull you right to their designated part of their website. You'll see the model plans and make them your own, adopt them, let your employees know. And I think you're going to find that your employees are really going to be very supportive of this, and they'll see that you're seeking to protect their interests, their health, their safety, and their welfare. So with that, we can flip back over to any other further questions if there are any. I think a couple came up as I was finishing up.
Yeah, so what's confusing is the wording. An employer must allow employees to form a committee rather than clearly stating you must form a committee. So
yeah,
really
so to be clear, on the workplace safety committee, employers shall permit employees to establish and administer a joint labor management workplace safety committee. The remaining verbiage beyond that is what that committee does and what the employee's rights are and how it's comprised. on this call are employers. You must tell your employees they have the right to establish this committee. Once you have done that, you have satisfied your obligation under this law. If your employees decide to establish this committee, there are additional requirements that must be met in order to fulfill the mandate under the law. So back to the original question, do you have to? We asked all of our 12 employees, none of them want to. Okay, document that, you let them know that's their right. And I'm big on documenting contemporaneous with when something occurs. So email, however you typically communicate. I would suggest you don't want to just have a conversation. Yeah, you know, Bill and I talked, and Bill talked to all the employees, and he says nobody wants one. Great. I don't think that's adequate. I want to be able to document it because of the enforcement provisions under this law. Your obligation as an employer is make sure your employees know they have the right to establish this committee. Give them a little bit of feedback on what the committee is about, what it would do. And then if they decide on their own they don't want to establish it, you're okay.
Will an employer need to have a policy in their employee handbook pertaining to the HERO Act?
That's a great question, and also probably a great way to address this. And I realize there's a large number of a large variety of employers on the call today. Some are small, some are big, some do have employee handbooks, some don't. I think no matter how big of an employer you are, you should have one, and you should make sure it's updated, even if it's as simple as a few issues with respect to conflicts. With, you know, there's a variety of things you can put in it. I think this would be a great thing to put in there. Take your the adopted safety plan and put it in there, and then every time you have a hiring, and that's another aspect of the law, you must notice every new employee of your workplace safety plan. Well, what easier way to do it than to put it right into your employee manual?
Are healthcare services covered under the OSHA ETS that was updated on July 13th, 2021, and are not required to create a prevention plan?
I'm not sure I know the specific answer to that. The way I would have to look at that.
Okay.
It could be that that's deemed sufficient if you have an OSHA adopted plan, if I understand the question correctly, but I'd have to look at that. That's a little bit more nuanced than I.
Should that person email you directly?
That would be fine. Yeah.
Okay. Ben put the direct link to the DOL, to the Department of Labor HERO Act. Okay, what constitutes adoption of the plan? We do not have a board. Will an email from HR to the owner saying this is our suggested plan for adoption and an email back saying approved suffice for the August 5th deadline?
I would say that that's sufficient. Okay. And
okay.
I think what you want to do is, however you normally adopt a new policy or procedure would be what I would recommend you do there. You know, I appreciate that a lot of your private employees, you don't have a governing board, you're sole proprietorships, you're an LLC. You know, I'll use Harris Beach as an example. We're a partner, we're a PLLC, we're a professional limited liability corporation. From the management side of things, we have a management committee, which is comprised of a number of partners within the firm that are elected by the partnership. When we adopt our plan, the management committee will adopt it and then have the partnership vote on it. That's how we do things when we're changing policies. So I suspect that that's how we'll do this. I'm guessing that's how we'll do this. By the same token, I could see the management committee saying we have the authority to simply adopt it, and we're going to adopt it, and here it is. So however you normally do that, I don't see anything in the law that would require a different or more elaborate process than you currently implement with your policies.
Okay. Is this the model plan to use? Model Airborne Infectious Disease Exposure Prevention Plan?
Yep, is it light blue on the top? I know we can't have an iterative dialogue here, but yes. So it says New York HERO Act, Model Airborne Infectious Disease Exposure Prevention Plan for, in this case, I picked up personal services and then retail industry. And it's, you know, it's extensive. It's 9-10 pages long. And what they do in the plan is they identify issues with respect to training and information during an outbreak, plan evaluations, and retaliation protection. So it's robust. it has, for those of you who did, you're supposed to be listening to me, not looking on the website. It's kind of like you give the exam back in the beginning of class and everybody starts looking at the exam instead of talking about what everybody did wrong on it. Hey, stop looking at the website. So, it has this and it goes on and on. It's got a lot of verbiage. So it's got a lot of blanks you can fill in. So, but yes, that's it. That's it. I know it's light blue. Maybe it's supposed to be the color of a nice blue sky that we haven't seen in a while.
I heard that by September 1st, the employees had to be notified and the plan had to be posted. Is this true?
So you want to get this out, as I said earlier, you want to have this plan adopted by the beginning of August. And when you adopt that plan, notify your employees it's there.
Okay. Was this law specific to 10 or more employees for private companies?
So two parts. With respect to the adoption of the plan, no. And I actually took another look at that just this morning because very often when the legislature imposes obligations on businesses, they're cognizant of the fact that small businesses, it can be unduly burdensome to have additional mandates put on them. In the case of the safety plan, that applies to every private employer. Nobody's excluded. Every private employer has to have one. And we were talking just before the webinar started as to why that is, and it's very simple. If we know from COVID does not differentiate between a big employer and a little employer. Anybody can get it. So everyone needs a plan. On the safety committees are those employers with 10 or more employees.
And when we're talking about employees, does this matter if we're talking about full-time versus part-time versus on payroll, contract employees?
No, it's literally the most broad definition of employee that you can imagine, including part-time. And I appreciate that some of the folks on this call may be like, really? I have a college-age son who's currently working at a running store, and I think they have 3 full-time employees, but they have about 15 total. And it applies.
Okay.
Because everyone else is part-time.
Do these plans resemble the plans that were mandated back in spring, summer of 2020?
Yeah, and I think these are a little bit more specific than those, but a lot of the same types of elements: hand hygiene, cleaning and disinfecting, respiratory etiquette. So a lot of that stuff is in here, and I think those who have looked at those I think we'll see a lot of similarities.
Are there any more questions for Douglas? Today's program is being recorded because we did cover a lot of information. We know that a lot of you are going to have to share this information with others in your organization, so we did record it. Everyone will get a copy of that recording later on today.
And just from my standpoint, I really appreciate the Chamber offering the opportunity to share some insight on this. I know new laws come out, particularly at the end of the legislative session, in a flurry, and having a little bit of dialogue on them, even if it's a half hour, 45 minutes, it's really helpful. If anyone on the call has some follow-up questions, I think my contact info is on that PowerPoint. You certainly feel free to shoot me an email or give me a call. I realize, that's just the nature of doing a program for the Chamber. More than happy to assist and help out and give you a little additional guidance if questions either arose that you didn't ask or arose after we end this. So don't hesitate.
2 more questions popped up. Is a verbal review of the plan mandatory?
I don't see that.
Okay.
Practically, why not, right? And frankly, as I look at it, and I just grabbed the retail industry one, thing's 9 pages long, right? You're going to give your employees this, here's the plan, or it's on the bulletin board. By a figurative show of hands, how many people think every employee is going to read it, right? That's why the wage and hour notification that's on the bulletin board is in 72-point font, because all you got to do is walk in and grab a Coke out of the fridge, and you see, oh, there's minimum wage. Oh, minimum wage went up because it's big and it's 1 page. This isn't 1 page. I would suggest to you, if you really want to make sure that this is implemented correctly when it needs to be, you do a verbal overview of the elements of this plan. This is what the expectation is, you know.
And then here's kind of a longer question. If you have a safety committee, does this need to be added to the committee, or can a separate committee exclusively for airborne viruses be created at the request of employees? If you have multiple unions and non-union staff, how should the makeup of the 2/3 of non-supervisory staff be determined for how many union versus not, if there is a requirement?
So the law does speak to the involvement of collective bargaining unions, and you'll need to work with the union to allow them to designate who they want on the committee. And again, this is going to be an employee-based committee. You'll want to make sure that you are universal in terms of, or fair in terms of taking employees from your respective unions and making sure they have a voice and have place on this committee. I would suggest that you leave more to the union. Perhaps you did determine we're going to have a committee of, let's say you have 100 employees, and you're going to say, you know what, the safety committee is going to have a dozen members, and then you tell the unions each union will have 3 or 4 or something. I'm not sure that that's something that you need to bargain with them. I think you as the employer will dictate this is the total number of people on the committee. Each union will have 2, 3, whatever it is. So that's, and so I think that answers the second part of the question. Can you restate the first, please?
The first was, if you have a safety committee, does this need to be added to that committee, or can a separate committee exclusively for airborne viruses be created at the request of employees?
If you currently have a safety committee, what I would suggest you do is consider whether that committee can take on the responsibility under the HERO Act, and to the extent that you need to add additional requirements to that safety committee because of the HERO Act, I think you can do that. You alternatively could have a second safety committee that strictly deals with the implementation of the HERO Act, because whomever's asking that question, I could envision you have a safety committee for a reason. You're an industrial employer. You have safety issues arising day to day. You're not in a law office like this where the only thing you're probably going to do is turn around and bang your knee on a desk drawer. No, that didn't happen today. You have forklifts. You have all kinds of operational issues that require your safety committee. So I think you have a choice here. You could do a separate one that's your HERO Act, or you could try to infuse it into your existing one.
Okay. If a business operates different types of sectors, like bookstore, daycare, overseas food service, would you suggest adopting a plan for each sector, or one plan trying to cover all areas?
What I would suggest you do is you have one plan. Within that, you may need to differentiate for your different sectors. Mm-hmm. So I am envisioning one document that may have some subparts. For our overseas operation, this applies. For this sector, this applies, and so on. So I think that would be. I haven't addressed that just yet with any of our clients, but that's how I would suggest doing it. Could you, as an employer, do a plan for each sector? I don't think the law prohibits that. I think that the goal is, let's get it out there. And if your sectors are separate enough, then you might want separate plans for each sector. Again, you want to make sure you're clear this is to implement the HERO Act, and you got every single element that's required by law. But that's how I would suggest you do it.
Okay. When we have to have this adopted and in place by September 6th, do we need to collect signatures from each employee and retain those records?
I would use whatever mechanism you have for distributing your policies. The law doesn't tell you this, okay? So I'm like I said, I'm kind of staring at the law right now. don't see anything that says how you disseminate that plan and how you ensure it. As the conservative legal advisor, I would say you need to do something to ensure the dissemination of that plan in writing to your employees. And a sign off, always a good idea. I know a lot of employers have social media policies. In other words, what you can and can't do on social media. And to ensure that every employee understands their roles and responsibilities under that, they have them sign off on it. And even sign off on it on an annual basis. You could certainly do that, but I would recommend having some form of record that it was disseminated in writing to every employee. Okay. The sign off is perfectly fine.
Douglas, Tom O'Connor, who's our VP of Government Relations, has been on this call and he's been looking up some things too. He said, yes, a verbal review is required. It's on DOL's Airborne Infectious Disease Exposure Prevention Standard, which is on their website. He just wanted to make sure everyone was aware of that. So he just wanted to put that out there for everyone. So thanks, Tom, for being on this call today with us. Douglas, we have another question that popped up. Please confirm what employers' obligations are if they don't have control over their HVAC systems. Example, employer is the tenant and not the owner of the building with regard to including engineering controls in their plan.
I really can't answer that at this time. It's that I don't see anything in the law that explains what you're supposed to do when you're not controlling your own HVAC.
Okay.
And I think that is a probative question, because some aspects of many of these plans have that aspect in it. That is enhanced filtration through HVAC. And a lot of us work in buildings we don't own, nor do we control, other than turning the heat and the AC on and off. So I think that would be an implementation piece that you would need to have a dialogue with your landlord.
Okay. Another question. We work primarily at customer businesses and homes. Do we need to confirm with our customers plan or conform with our customers plan or ours? Confirm with our customer plans or ours, I'm sorry.
Your customer's plan, and I'm presuming we're business to business, your customer plan should address how visitors, including contracted entities such as the business asking the question, need to comply. So presumably there would be some consistency there. I'll use an extreme example. Your plan says you have to wash your hands 4 times a day. Your customer says 8 times a day or 2 times a day. You know, I would seek compliance with both. But I would presume your customer is going to tell you, as a visiting entity, I guess client, this is what we need you to comply with. You're in their location. Again, backing out of this just one step, we're trying to deal with the limiting of a airborne illness in particular, whether it's COVID or another. So anything you can do to mitigate that is really going to be what's going to rule the day. When you're in someone else's business, you're going to want to make sure you're complying with their plan for that reason.
Some items in the model plans have items that do not relate to our situation. Do we keep those in the plan anyway? In other words, do not make changes to the model plan other than the blank areas that allow us to add more?
Yeah, that's a really good question, and I actually had the same question, because I think the model plans seek to be really all encompassing, but there could be provisions of it that just don't apply. As you draft goes, I would do everything I could to keep as much of that in there as you can. And remember, it's a model. So if you've taken something out, you've identified that it simply doesn't apply to you. And I think that would be better than having a requirement in there that doesn't apply, because then what are you going to do? You're going to be non-compliant with your own plan, and your answer to that is, well, because it doesn't apply, but I left it in there because DOL put it in there. It doesn't make, it doesn't make sense to keep something in that doesn't apply to you. But I would make sure it doesn't apply.
Okay, and then another question, if the employees initially decline forming a safety committee, is the option still available to them at a later date? How often should an employer make employees aware of their right to form a committee?
So law doesn't say anything about that, but I would say you would at least want to do that annually.
Okay.
But yes, if the employees, and I go back to one of the first questions on this early this morning, where I have 12 employees, they don't want to do it. Okay, well, you know what? 4 months from now, they may decide, we do want to do it. It's not a one-shot. The law says you have to permit it. They've now indicated that they want it, even though they initially said they don't. You have to permit it.
Well, Douglas, I want to thank you again for your taking the time today to share this important information with everyone. I really appreciate it. Thanks to everyone that participated this morning. I hope everyone keeps an eye out for the recording and the materials we mentioned. Take care, everyone. Stay safe and have a great day.
Thank you again.
Thanks.